So हम आज फंडामेंटल राइट्स के बारे में पढ़ेंगे. We'll go with for today in detail. We'll cover article 12, 13, 14, 15. Okay. In detail we'll cover, like जितना हम कर सकते हैं थोड़ा डिटेलिंग में करेंगे ताकि हेल्प हो जाए, so that it will help you in both prelims and mains. Fine. So fundamental rights are natural rights which are inherent in human beings. ठीक है, इट्स ऑलरेडी देयर. मतलब ऐसा कोई नहीं है कि आज आया है. इट इज रिकॉग्नाइज्ड एज एन इनहेरेंट इन ह्यूमन बींग्स एंड कैन नॉट बी टेकन अवे बाय द स्टेट. द स्टेट कैन नॉट टेक दोज राइट्स फ्रॉम यू. ठीक है, हिंदी में बोलते हैं मौलिक अधिकार. दे कैन नॉट टेक अवे फ्रॉम राइट्स. इट इज इनहेरेंट इन ह्यूमन बींग्स. Part 3 of the Constitution, which contains fundamental rights, has been described as the Magna Carta of Indian Constitution. So this Part 3 is called as the Magna Carta of Indian Constitution. Now this Magna Carta is nothing. Magna Carta has come from UK 1214 AD. So like it's a very British concept, like from medieval times, which recognizes human rights. Okay, so that's why fundamental rights also recognizes our rights. That is why it is called the Magna Carta of Indian Constitution. Okay, now this term will come a lot of times in modern history. Magna Carta of Education, Magna Carta of our Constitution, lot of things. Article Government of India 1919, Government of India 1935, Government of India of 1858. Like everything has different Magna Carta. So that is a detailed part of modern history. Okay, when you go through detailing in modern history, we'll come to know. Normal books may will not find, but things are there in modern history. Okay, that we will cover when we cover modern history. Fine. So Magna Carta of the Indian Constitution, that is the heart and soul of Indian Constitution. It is the heart and soul. It substantially covers all political and civil rights enumerated in the Universal Declaration of Human Rights. Universal Declaration of Human Rights. Last year question came 1949. United Nations had adopted these rights. It's a convention of recognizing human rights. Okay. So most of the rights mentioned in this declaration has been covered in our fundamental rights in our constitution. Okay. Justice Gajendra Agarkar described it as the very foundation and cornerstone of the democratic way of life ushered in this country by the constitution. So if you see some test series, vision ka test series dekhoge, bahut sare test series mein you see na, which of the following is the foundation and cornerstone of democratic way of life ushered in this country by the constitution? This is fundamental rights. Okay. It was deemed essential to protect rights and liberties of Indian citizens. It is protecting, like fundamental rights are our rights. The state, the government cannot arbitrarily come with a law which is affecting our rights. It cannot do. Who protects it? Like what are the provisions? It is the fundamental rights which gives us that right. Okay, nobody can arbitrarily rule us or arbitrarily put something which is against our right. We can go to the court. We can go to Supreme Court. We can go to High Court to enforce or to file against the tyranny of the government. It was deemed essential to protect rights and liberties of the Indian citizens. These are limitations upon the powers of the government. That's what I said. It is the limitations. The government cannot simply come and put anything on you. These are the limitations on the powers of the government to something which is these are for citizens. These are our rights. Okay, fine. In Menaka Gandhi case, 1978, very important case. It is one of a landmark case which we cover in mains. We had covered, but I'll tell you today also. In Menaka Gandhi case, Justice Bhagwati observed these fundamental rights represent the basic values cherished by the people of India since the Vedic times, and they are inculcated to protect the dignity of the individual and create conditions in which every human being can develop their personality to the fullest extent. It's saying that these rights have been cherished by people since the Vedic times, and they are in particular. If we talk about Menaka Gandhi case, so it talks about Article 21. Okay, it is a broad interpretation of Article 21. Okay, it extended the Article 21. Article 21 was very narrow till 1978. ठीक है. It was simply a one-liner article, right to life and dignity. Okay, it was simply a one-liner article. But after this case, and today in 2022, we have lot of things inside Article 21: right to environment, right to privacy, right to passive euthanasia, right to lot of things, right to sanitation, right to choose your partner, anything. Lot of things are done. These are all done by Supreme Court. Most of the time, Supreme Court, judicial pronouncements. Because of this case, after this case, everything started. After this 1978 case, everything it started expanding. For example, in 1987, there was a Mehta case where they said कि right to environment, right to environment. Okay, so all these things, it's like in 2016 privacy का आ गया, right to privacy. So because of this, now why there is a difference, I'll tell you now. Note it down why this came. Before starting, I'll just give a brief introduction of Article 20 so that you get to know what exactly happened in the Menaka Gandhi case. There is a difference between due process of law and procedure established by law. It can come as a mains question and also in a prelims format. Procedure established by, you need to know the basic difference. Procedure established by law. Okay, so how to explain both these things? See, first of all, we will go to due process of law. Okay, procedure. Now here, this is Indian, this is in our side, we cover this procedure established by law. Okay, in due process of law, what happens? Suppose if a case, suppose you do something, okay, against a law, a case will happen, right? So case will be under some law, or case will be filed under some section of IPC, right? Whether it's against Environment Protection Act or a Wildlife Protection Act or some IPC. Whenever you see a FIR, you will see this is the case under this section, under IPC this. Then it goes for trial, right, to the court. Okay, so here what happens? The judge, here first of all, the judge will see one thing, whether it is the right, whether the offense is correctly under that law or IPC. Okay, number one. Then they will check the intention of the lawmakers. The judiciary will check the intention, whether this law is correct or not. Intention, when they made the law, whether the intent was good or not. If the intent is wrong, then it can make the law as void. That is due process of law. It happens in Western countries, US, not here. Okay, in procedure established by law, as the literary meaning goes, procedure established by law, anything like whatever is written in the law, the court will do accordingly. Whatever is mentioned in the law, same thing. Like here also, if something happens, the judge will first see whether there is a law correct, it is filed under correct law or IPC, whether first of all the law is there or not. Okay, the law should be there. If you are committing something, it should be under some law. Okay, second, here they will not check the intention. The judiciary will not check the intention. They will not check the intent. They'll simply go by the law. What is mentioned in the law or IPC? The procedure established by the law. What is mentioned in the law? Laws are very big, right? Laws are not 2 to 3 pages. Laws are very big. You study it, or we study it from an exam point of view. Okay, these are very big laws. Like those are in law student can understand very nicely. So the procedure established by the law will be followed by the court. Now here this has nothing to do with basic structure of the constitution. That is a different issue. I'm simply talking. Obviously, if anything hampers the basic structure of the constitution, then the judiciary can do it void. That is okay. That we'll read. But I'm talking about just this process. So this was continuing. This is still continuing for everything. But in 1978, Menaka Gandhi said Article 21 is about human life and dignity. It's about human life and dignity. How can you keep human life at stake? A law can be bad. You cannot say a law can be good. A law can be bad. It can affect our human life. But here judiciary doesn't have any power. You have to go as per the law, whether it affects life or not. But that is not good, na? That's why Supreme Court included procedure established by law, like Article 21 also comes under this ambit, due process of law. It was already there. Now Article 21 comes under this. This was the main thing which happened in, and because of this, because of due process came, human life is more than anything. You simply can't give supreme power to the government or the state or to the legislature to do anything which will affect your human life. And that is the due process of law was included. The interpretation became broader. Environment, right to life, right to this, right to that, everything started coming inside or inherent in Article 21 as per judicial pronouncement. Okay, this is the main basic thing. Everyone understood? This is the basic thing of Menaka Gandhi case. A mains question will come. You have to just write what I said. You have to write it in your own language. Fine. Okay. So anything related to Article 21, always Menaka Gandhi case you have to mention in your paper. You have to mention. This is the biggest case of Article 21. It changed the whole course of fundamental, like our thinking towards fundamental rights in 1978. Okay. So part 3 is Article 12. So we'll be studying Article 12 to Article 35 of the Constitution. Contains the provisions related to fundamental rights given to the people of India or Indian citizens. Fundamental rights are very important for the overall development of a human being. Yes, they are important. Fundamental rights provide protection against the illegal action of the state. That is what the basic thing of fundamental rights. It is protecting against any kind of arbitrary or illegal action of the ruling party or the government of the state. The state is prohibited to take away or abridge them. The state cannot take away. Yes, it can amend the fundamental rights. Yes, it can amend, but it can take away from us. It cannot take away. See, take away or abridge them does not mean it cannot amend. They can change. Lot of things have been added. Recently, EWS was added. Article 16, 15. In 16 it was added. Some clause 5 or clause 6 it was added. So changes can be done. Article 21 clause 1. Article 21 was already there. Clause 21A was added. Right to education. So it can amend. But yes, again, it can amend, but it cannot touch the basic structure. That we will study. It cannot touch the basic structure of our constitution. Okay, next. Fundamental rights are called negative obligations on the state. Yes, it acts as a negative obligation, right? Because the state cannot do anything. But the state cannot do anything arbitrary. Whether they have majority or not, they cannot do anything like arbitrary. So it is called negative obligations of the state. Granville Austin has described them as the cornerstone of Indian democracy. These are the cornerstone to preserve our Indian democracy, because we vote, right? If we vote, so the source of power is the people. People are the source of power. We choose a government. We can change the government. We only have the power, right? So if we are the main source of power, so our rights should be preserved. That's why fundamental rights are there. Cornerstone of Indian democracy. And together with part 4, that is the DPSP, it is called the conscience of the Constitution. DPSP, Directive Principles of State Policy, plus fundamental rights are called conscience of the Constitution. After this, we'll be studying what are DPSPs. In case of an encroachment by the state on any of the fundamental rights, The Supreme Court and High Courts are competent to declare the law or the act as unconstitutional and accordingly void. If any law, if any law made by the government is abridging or it's encroaching our fundamental rights, then only the Supreme Court and High Court have the power to make that law void. Only Supreme Court and High Courts, remember, district courts do not have the power. Okay, now Article 12, very important. I'll tell you how to remember. Okay, now everything which you will study here, the term state will come from Article 13. If you see the state, everywhere the term state will come. Now what is the state? The definition of the state is mentioned in the first article, Article 12. So it defines, this article defines the term state as used in different articles. In different articles, Article 15, 16, 17, 18, you will see the word state. State, basically it is the government, but yes, it's a like there is a long connotation of the term state. So the term state includes which of the following? First of all, the government, obviously. The parliament. Parliament is nothing but the government. Okay, that is the executive, legislative, like any law. They see legislatives will do law. That is, they'll do act. Executive will do rules. So any rules also included here. Any rules made which is abridging our fundamental rights also, then also we can go to court. Article 32, we can go to court. Government and the legislature of each state, this is India, this is state, same thing. All local or other authorities within the territory of India, within, okay, not outside, authorities within the territory of India. All local or other under the control of the government. It can be state or in any government. Okay. So the term state thus includes executive as well as legislative organs of the union and the states. Very clear?
Excuse me, sir.
Yes.
Sir, Indian embassy दूसरे देश में ये state होगा?
Within the territory, though they can't happen because within the territory, Indian embassy is outside the territory. It is outside or within the territory.
But वो Indian part ही होता है ना sir?
Indian part होता है, but here we are talking about only fundamental rights. Yes, they are coming under Indian, but everything other things okay. But here the thing is fundamental rights. Obviously, they can't do something. Embassy can't, मतलब बाहर का जो embassy है, they can't do something which will affect our fundamental rights. So what they will do, which will affect our fundamental rights. But till now nothing has happened. But again, if something happens in future, again Supreme Court will be there. Somebody will file a PIL. Again interpretations will come. That is the thing. That is the beauty of our constitution. Nothing is absolute here. Anything can happen anytime. But as of now, as per this Article 20, we will go within the territory. We will go word by word within the territory. It is clearly mentioned. Okay. Fine.
Excuse me, sir.
Yes.
Sir, but in the fourth point, it is written all the local or other authorities under the control of government. Indian embassy operating in the other country will be under the control of our government.
Yes, but here local authorities. See, the thing is here all local authorities or other. Okay, you are talking about other authorities.
Yes, it can come under the other
It can come. It can come.
Under the control of government.
Under the control of government. Yes, it can come. But still, then if you see point 4, but again, if you come to point 3, point 3 within the territory. So that's what I'm saying now. Thing hasn't happened till now. Okay. If it would have happened, some case would have come. So we would have covered it, right? Till now, nothing has happened because point 3 is doing that. Point 4 is again, if you see on a broader connotation, so it is not coming. So we have to wait. If something comes, if suppose if you want to discuss, we can discuss. Okay, fine. An embassy will make some rules, but the thing is, it is a very very weird thing. What rules they can make, which will affect us? What rule? Well, the rules are made mostly by either a third tier panchayati raj or a state government or a central government, right? And rules are actually made by the parliament or a state legislature or a third tier, and that becomes obviously the rules are for territory India, right? They are not from people staying outside. Generally, I'm speaking, but still, then these are things which are these are debatable. Okay, these are debatable. But till now, no law, nothing has happened till now. That's why the thing is, nobody has come with a particular definition of it. If something happens outside, what happened? But if you go for point 3, then within the territory. If you go for point 4, they are under the control of the government. But still, then it is says this, the thing is 3 clause is opposing clause number 4. Lot of things will happen in future, like look, article 14, article 15 comes with the opposition to article 25, religion equality. So all those things happens. Okay,
Okay, sir.
ठीक है. The term state. Now one more thing, if these kind of, so if you are very clear on your concepts, if these kind of question comes in, obviously they will come in UPSC, they will not come in state exam. If this comes, so do not leave, attend and come. Okay, because these are debatable questions, grace marking मिल जाती है, you will get a grace mark. हर 2 साल 1-2 साल में एक दो क्वेश्चंस डिबेटेबल रहते हैं. ओके, सो ऑलवेज अटेंड इट, एनी काइंड ऑफ डिबेटेबल क्वेश्चन ऑलवेज अटेंड इट, डू नॉट लीव इट. ओके, ठीक है. द टर्म स्टेट thus includes executive as well as legislative organs of the union and the state. Fine, it is the acts of these bodies that can be challenged before the courts as violation of fundamental rights. So these bodies, if they do something which is against our fundamental rights, then we can challenge it as in the court as a violation of our fundamental rights. This definition is not exhaustive, but it is kind of an inclusive. The executive and legislative organs of the union are quite specific and they're self. See, here they have clearly mentioned ki okay, executive and legislative organs are very specific and they're self-explanatory. Yes, but again they have not the doubt we are talking now कि outside अगर होगा embassy में हो तो क्या होगा, because the thing is वही चीज होता है ना, 3 point is negating the 4th point, so obviously they will not mention. Local authority. Now coming to local authority. Local authority is defined under section 3 of the General Clauses Act of 1897. It refers to authorities like municipality, district board, panchayat, trust, mining settlement boards, all are kind of state. If also they do something which is against our fundamental rights, you can go and sue them in the court. Okay. Now these other authorities. Okay, what are these other authorities? So there are legal interpretation of the term, because constitution may only written other authorities. You can't simply say what other authorities can be anything, right? So a lot of things have happened in the court. We'll come to that now. Other authority is not defined. See, the thing is, it is not defined in the constitution or general clauses. Therefore, we are bound to find its meaning in judicial decisions. So, the judiciary has given some decision, we have to go via that, because it is not defined in our constitution. In this case, Shantabai case, no need to remember these case names. Okay, no need to remember. The Madras High Court held that other authorities could only indicate authorities of a like nature. Simple like nature. That is the in the law language you can see. Ejusdem generis. No need to remember this. Like a same species. Like we simply cannot think okay, ये ऐसा क्यों हो गया? Why that thing is not coming? It has to be a very like nature in the sense it has to be very like believable lage. Okay, it could only authorities of a like nature. If so construed, it could only mean authorities exercising governmental or sovereign functions. Any authorities which is functioning government functions. Okay, fine. It cannot include persons, natural or juristic, such as university, which is involved in educational or welfare activity. No, that is not included as a state. But this restrictive interpretation again of Madras High Court was rejected by Supreme Court in 1962. Lot of things happened. They will go for the latest one. Okay, this is just an evolution. It was held that this rule, this is the same species rule, could not be resorted to while interpreting this expression, as there is no common genus running through these named bodies in Article 14. Nor can these bodies be placed in one single category or on any rational basis. We can't simply place all authorities in a simply one. Every body has different functions, right? We cannot simply put them in one box and tell, okay, we can classify them, or we'll try to put them in a very like nature. We can't do. Then what happened in 1967 in a electricity board Rajasthan case, the Supreme Court held that other authorities would include all authority created by the constitution, created, or a law created by any body created by a constitution or a law, whom powers are conferred by that law or some other law. It was not necessary that the statutory body or the statutory authority, that is the body which comes from a statute or from a law, should be engaged in performing government or sovereign functions. Very important point. These 2 points are very important. Now the Supreme Court said, okay, other authorities can be anybody, but it has to be created by a constitution or from a law. But it is not necessary that that body should be engaged in performing government functions. It can perform some non-government functions also, but it has to come from a law. A law means nothing but a government, no? So in a way, these are all judiciary language, okay? So in a way, you can say it has to come from a law, but it does not necessarily mean that it has to do government functions. So this is the Now in prelims, they will ask difficult questions, right? So they'll simply take the statement, just twist it and put it. So you have to understand from your in your local language. It should be created by the law or a constitution, and it should obviously it should do government function, but it is not necessarily. This is the keyword here. Okay. Okay, next. So other authority, same thing. Shanta Baike, same thing as written from another book, same thing. Other authorities could only indicate authorities of a like nature, same thing. Rajasthan board also gave the same thing. Now come to the modern concept of state. Now this is a very important mains question or from a prelims point of view. Where they can ask what are the modern, like they'll ask you something about Article 12, what is the state, mention something, then they'll what are your views on the modern concept of state. Okay. Now modern means some 70s, 80s, जब थोड़ा बहुत nearly 20, 30, 40 years का जो है. Okay. So in one case, 1975, in this case, Justice Matthew preferred a broader test and gave a modern concept of state and talked about the agency and instrumentality of the state. We'll come to that. What is that? So what happened is, so he said कि okay, like we have to talked about the agency and instrumental. मतलब वो state का मतलब how does it work? कहाँ से आया है? क्या काम करता है? What does it do? वो state. So उस सेंस में ही हम उसको as a state लेंगे, we'll call it as a state, or we'll call it as it's not a state. Okay. The modern concept of state, earlier given by Justice Matthew, was finally summarized by Justice Bhagwati in 1979 R.D. Shetty case. In this case, it was held that if a body is an agency of government or instrumentality of government, it may be an authority within the meaning of Article 12, whether it is a statutory or a government or a registered society. Okay. So modern concept is, they clearly said कि whether the body is an agency of or maybe an authority only when it is a statutory, like coming from a law, it's only a government company, okay, or even a registered society. Lot of registered society, because registered society also comes from a law, right? Registration Societies Act of 1860. Okay. So any society you have to register through a law. There is a law for that. Okay. So indirectly everything is going through a law. Government company, Companies Act 2013. So indirectly everything is like connected to a law. Okay. So finally we can say, okay, law should be there. But it may function a government thing or it may do a non-government function also, but it should come from a law. So that is the final thing. Okay, in another case, 1981, if you do not remember the case, you can only write as per Supreme Court or as per judicial interpretation. This is the term you have to use. If you do not, UPSC do not expect you to write case names in GS unless and until it is a very important case. Okay, and important case I'll be telling you. These are the important cases which you have to write the case names. Okay, now finally what happened in 1981? So these are the three things, modern concept. In Khalid bin Mujib case, the Supreme Court laid down the following tests for determining whether a body is an agency of a government or instrumentality of a government. Okay, the Supreme Court laid down some guidelines. Okay, this has to be there if you want to be recognized as a state. Financial resource of the state is the chief funding resource. Chief funding, like if any agency is there, the funding, the chief funding. I'm not here telling the only funding. If chief ke jagah only aa gaya, it will be wrong. It cannot be a state. Like obviously it will be a state only funding, but it can be chief. Like सबसे ज़्यादा funding government से आना चाहिए. The financial resource of the state is the chief funding resource or source. Sorry. Existence of deep and pervasive state control. The government should have a control. Obviously, if it's coming from a law, so the government has a control, right? Because the laws are created by the government only. Functional character being governmental in a sense, that is, if the functions of the corporation are of public importance and closely related to governmental functions. Like what are the function? वो agency करता क्या? What does it do? What is the function? It should closely be related. We are not saying you overall 100% government, but it should closely be somewhere or the other. It should be related to the government function. Okay. And obviously, if the functions of the corporation are of public importance, so that is automatically anything on public interest is kind of it becomes it comes in a priority basis. Okay. If a department of a government is transferred to a corporation, that is also can be considered as a state. Now, these are the things which you have to remember from a prelims point of view. Also, they can ask you which of the following situations can be considered for determining or defining a agency as a state under Article 21. 1, 2, 3, 4, 5. Select. So if a department of a government is transferred also to a corporation, that also be considered as a state, because corporation means company. Company means you have to register under an act. Automatically it becomes a state. Whether the corporation enjoys monopoly status, which is state conferred or state protected, this also becomes a condition. But now the thing is, these conditions are given by judiciary. These conditions are not given by this constitution, because the other authorities term is not defined. Just you have to remember these 5 points. The court said that these states are not even conclusive and clinching, but illustrative only, and will have to be used with care and caution by the court. These are not conclusive, like these are not the final thing. You can use it because our constitution is evolving day to day. Okay, in 1950 things were different, 2022 things are different. It is evolving. Okay, now one by one. Private educational institution, state or not? Private. Now the thing is private. So पता चल जाता है private means it is not government, right? So the Supreme Court clearly said a private educational institution, either by recognition or by affiliation to the university, could never be called an instrumentality of the state. Now the thing is, you will link. You may link. If you do not know this, you may think from here and link. Private also they have affiliation, right? Private also had affiliation. UGC. UGC is what? It is a law. UGC Act 1956. Now you will think, okay, it is done by UGC, funding UGC aate hai, to government, so okay, it will be a state. No, clearly the either by recognition or by affiliation could never be called an instrument of state. This is the trick here. Okay, clearly Supreme Court has said, and it is a recent case also, 1993 case, Unni Krishnan, and it is important case also, Unni Krishnan case. Okay. I have also put one question you can check in my Telegram channel. Like they'll ask which of the following comes under the definition of state. BCCI, NCRT, some private educational institution. They may ask like this also. Okay, NCRT state or not? See, in Chandramohan case versus NCRT, the Supreme Court held that NCRT is an autonomous body and a registered society. Okay, so registered society means it is a registered. In top we studied that registered society also will be considered as a state. Now see the interpretation, how it is evolving. So it said an autonomous body and registered society, and mere state control does not render it state. Under Article 12, in order to come under the purview of the state control, body must be under pervasive control of the state. Now see here, court said, see how it is different, how the things are getting changed. It should come as a pervasive control, but NCRT, fine, it is under a registered society, okay, but still then it acts as an autonomous body, right? So to become a purview, to become a member, to come under the ambit of Article 12, it should be under pervasive control of the state. So NCRT is not a state. Private education is not a state. Just remember this much. You don't need to go through all this for exam point of view. Just these are not state. Next. CSIR, state or not? Council of Scientific and Industrial Research. When it happened? Pre-independence or post-independence? 1944. State or not? In this Pradeep Kumar case, Indian Institute of Classical Chemical Biology, it comes under CSIR. The in 2002 case, very recent, the Supreme Court held that CSIR is an instrumentality of state falling under scope of Article 15. Because why I'll tell you, because it gets funding from Ministry of Science and Tech. It does not come under Ministry of Science and Tech. Remember, you can check in Wiki. It does not come under Ministry of Science, but it gets funding, and there is a provision if you get a funding. So It can be considered a state, and even the court has also recognized. So it comes as a state. Now BCCI state or not? See, BCCI का केस हुआ था, BCCI केस वर्सेस क्रिकेट एसोसिएशन ऑफ बिहार 2015, वेरी रिसेंट. ये सुप्रीम कोर्ट सेड कि BCCI is a registered society. Yes, it is registered, but it is not a state. Within the it is not a state, because if you know BCCI nicely, it works independently. It is a registered society, okay, fine, but it works independently. उसका अपना बोर्ड रहता है, उसका अपना कंट्रोल रहता है. They do it independently, right? Now the most important thing, judiciary comes as a state or not. See, in Article 12, nothing has been mentioned about judiciary. Judiciary comes. It has been not mentioned. Judiciary is not there. So, like in a blind man term, I can say, okay, judiciary is not there. But if you want to go deep, then you have to understand what exactly is there and what exactly is not. Overall, judiciary is not there. If the simple question comes, judiciary is not considered as a state, that is okay. As per Article 12, judiciary does not come under state. That is final thing, fact. But as per judicial interpretation, what happens, I'll tell you. In this 2015 case, State of Assam versus Riju Prasad Sharma case, the Supreme Court said that judiciary in India acting on its judicial side, remember the term, on its acting on its judicial side, cannot be considered as a state. If it is acting as a judicial, giving verdict, giving this, giving that, it cannot be considered as a state. If it gives a verdict, now that verdict affects your fundamental rights, nothing can be happened. You cannot go to court and say this is doing, because it is not considered as a state. You have to file a PIL if something, your fundamental rights are infringed or it is taken away. You have to file a PIL against something, right? Who is taking your fundamental rights? Whether it's this government, or it's a judiciary, or it's that authority, or it's NHA, or it's a BCCI, or anything, you have to say, na. If a judicial verdict is affecting your fundamental rights, you cannot go. For example, verdict will say, okay, you will get this death penalty. You simply can't say it is affecting my fundamental rights. Okay, so that is the judicial side. Okay, but only when the courts deal with their employees or act in administrative matter capacity, they fall under the definition of fundamental rights. But when you are doing any administrative matter, like any kind of internal rules or administrative rights and administrative capacity for doing something, and it is affecting your fundamental rights, then you can go against that. Clear? Okay. So in prelims exam, you have to be very particular ki what is mentioned. They will mention something. They will mention as per constitution. So as per constitution, this does not matter anything. You should not think about this. But as per judicial interpretation, if the question comes only, like in the question comes, consider the following statements, dot. Then you can take these as take judicial interpretations as an account. You can take into account. Okay, but if the question comes, consider the following with reference or with respect to our Indian constitution, then these things should not be taken into account. Lot of questions I have seen, most of the people have asked me doubts also last year. So you think you will know it, but you miss the word as per our constitution. As per our constitution will be mentioned. So as per our constitution means you should not think all this. These are all judicial interpretations. If the question comes, consider the following statement, dot. Then statement comes, then you can take into account the constitutional provisions, you can take into account the judicial provisions. Clear? So always be very careful in reading that words. क्योंकि एक word के अंदर ही वो trick छुपा रहता है, खासकर because people 7 to 8 lakhs people come ना, so ये सब tricks बहुत ही important होता है exam के लिए. Fine.
सर तो मतलब कि अगर कोई सीधा सवाल रहेगा कि इनमें से कौन सा स्टेट है और सुप्रीम कोर्ट भी रहेगा, तो उसको हमको मानना पड़ेगा स्टेट है.
ऑब्वियसली हाँ, सीधा सवाल अगर रहेगा इनमें से कौन सा स्टेट है या फिर नहीं है, तो ऑब्वियसली आप जुडिशियल लोगे ना. अगर ये सब आएगा ना सीएसआई, तो जाहिर सी बात है जुडिशियल के बारे में पूछ रहे, जुडिशियल इंटरप्रिटेशन के बारे में. ऑब्वियसली वैसा क्वेश्चन में वो एज पर द कॉन्स्टिट्यूशन नहीं पूछेगा. बिकॉज इनके बारे में कॉन्स्टिट्यूशन में कुछ लिखा ही नहीं है, CSIR BCCI जुडिशरी के बारे में आर्टिकल
नहीं
12
सर,
में लिखा नहीं है।
सर केवल जुडिशियरी के लिए मैं पूछ रहा हूँ कि अगर केवल आएगा कि इनमें से कौन सा स्टेट है, तो अगर जुडिशियरी रहेगा तो वो भी स्टेट में आएगा, है ना?
नहीं, अगर एज पर कॉन्स्टिट्यूशन होगा तो नहीं आएगा।
हाँ, एज पर कॉन्स्टिट्यूशन अगर नहीं रहा सवाल, केवल नॉर्मली रहा कि इनमें से कौन सा
हाँ तो
स्टेट।
आएगा, हाँ तो आ रहा है, उसका एक पार्ट आ रहा है,
यस सर।
बिल्कुल आएगा।
और सर यूजीसी स्टेट है या नहीं है?
UGC इज अ स्टेट ना,
यस सर।
UGC is come from act ना, UGC Act 1956, डायरेक्ट इट्स अ स्टेट। UGC है, बट UGC अफिलिएट भी करता है ना प्राइवेट इंस्टीट्यूशंस को। Those institutions do not come under state. You have to be very clear. Okay, anything which comes from an act, that is a state. मतलब पूरा मतलब आप वो मान के चलो। ओके नेक्स्ट, तो मॉडर्न कॉन्सेप्ट से और अच्छे तरीके से वही चीज़ है, बहुत अच्छे तरीके से आप मेंस के लिए यहाँ से लिख सकते हो, वही चीज़ है। इन द सुखदेव सिंह केस, जस्टिस मैथ्यू प्रीफर्ड अ ब्रॉडर टेस्ट एंड गेव द मॉडर्न कॉन्सेप्ट ऑफ स्टेट and talked about agency and instrumentality of the state. The modern concept of state was given by justice in the above cases was finally summarized in the Justice Bhagwati case. Okay. So the thing is, suppose a question come about modern concept of state. So first of all, you define what is a state as per Article 21. That will work as an introduction. Then start from here. Then you can start from here. No need to write this also. You can start from here and talk about this. Give this over 150 words. Very easily you can write. So according to him, the functions of the corporation are of public importance, which are closely related to the governmental functions. It should be treated as an agency of a state, and hence under the ambit of Article 12. In this case, if it was held that if a body is an agency or instrumentality of government, it may be an authority within the meaning, no matter whether it is a statutory corporation or a government company or a company registered under Companies Act or even a registered society. They all comes under state. But yes, BCCI is also a registered society, so BCCI here acts as an what? Exception. It works as an exception. But yes, if modern concept can direct puchega, so you can write this. So Supreme Court propounded following illustrative test for agency: control of the government, financial contribution of the government, monopoly conferred by the government, etc., etc. You can write. Now again, clearly it is mentioned here. You can check here the examples for prelims point of view, which comes under state and which do not come under state. You can check from here. Okay. So these are coming under state. ONGC, International Airport Authority of India, DVC. These are all, DVC comes from an act. Damodar Valley Corporation, Bharat Petroleum Corporation, IOC, ICAR. ICAR comes in. It is a modern history concept. It comes from 1929 from Royal Commission on Agriculture. Royal Commission on Agriculture of 1927. They recommended ICAR. Okay. RBI, IFC, Indian Financial Corporation, FAIR, LIC, State Bank of India, Central Inland Water Transport Corporation. Now see, judiciary while performing non-judicial function comes under state. I told you, from that case, judiciary functioning while non-judicial function, it is a state. Functioning judicial function, it is not a state. As simple as that. DDA, universities, okay, obviously it's not private universities. DTC, IDBI, CSIR, FCA, Food Corporation of India, it comes from an act. SAIL. So non-state cooperative society, NCERT, judiciary exercising judicial function, not state. BCCI. So these are all come from judicial interpretation. These are not mentioned in article. In Article 12, these comes under comes as judicial interpretations. Okay. So you have to remember which comes under state, which do not come under state. You can expect one question anytime in exam. Okay. So now we'll go to Article 13. Article 13 is laws inconsistent with or derogation of the fundamental rights. What happens to any kind of law which is not which is against a fundamental rights, which is only against a fundamental right? We are not talking about laws which is against the constitution. We are not talking about that. We are only talking about which is against fundamental rights. It states all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. So in clear we'll say कि any laws which is inconsistent will be void, okay. So this is the first part, clause. The second clause says the state shall not make any law. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall to the extent of contravention be void. So basically it will be void. Just remember, it will be void. Okay. We'll come to the explanation part. In this article, unless the context otherwise requires, law includes. So clearly it is mentioned ki what are the things which are included under the ambit of law. Those include any ordinance. So you have to remember one by one. Any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. So anything via an ordinance, via an order, via anything, okay, if it is against the fundamental rights, so it can be to that level of inconsistency, it will be a void. The judiciary can do void. Obviously it will be done by judiciary, right? So it can be done void, okay. Obviously to that level of inconsistency, this is the term mentioned in clause 1, to that level of inconsistency. It does not mean there is a law has lot of provisions, right? Suppose only this provision is against the fundamental rights, only this will be void. It does not mean that the whole law will be void. That is the doctrine which has used by the Supreme Court or judiciary. We'll come to that, okay. I'm not saying the whole law will be void. To the level of that inconsistency, this provision is problematic, so this provision will be declared as void. If the whole law is problematic, the whole law will be declared void. If this provision is related to other provisions, so all the law provisions can be declared as void. So it depends. So to that level of inconsistency, okay, fine. So you have to remember one thing: ordinance, usage, okay. Can you see one thing? In under the section of law, is anywhere written constitutional amendment? It is also a law, right? Constitutional amendment under Article 368. Is it mentioned anywhere? No, right? So this is also a law, right? Constitutional Amendment Act of 2019. It is nothing but a law. Act, it is getting passed in the parliament. So it is a law. But constitutional amendment does not come under the Article of 13 because it is not mentioned. As simple as that. Is it mentioned anywhere? No. Okay. Second, laws in force includes, which are already in force, includes laws passed or made by the legislature or other competent authority in the territory of India. In the territory of India, okay. Before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation, either at all or in particular areas. So basically, laws in force, whether before the constitution was made, after constitution also, if it is against our fundamental rights, so it can be considered as void. Now one by one, Article 13(1). Article 13(1) deals with pre-constitutional law and provides that inconsistent laws will be void to the extent of such inconsistency with the fundamental rights. Any pre-constitutional law which is there. What are pre-constitutional law? Before constitution, Forest Rights Act, environment topic, 1927, pre-constitutional law. Till now it is working. So anything, if it is inconsistent, any provision to such inconsistency will be declared void. Very simple. Clause 2. Clause 2 deals with post-constitutional law and prescribes that the state shall not make any law which takes away the fundamental rights, and law in contravention of fundamental rights shall be void. If any law which is taking our fundamental rights also, it will be void. If it is contravening also our fundamental, both are mostly the same thing. It is also contravening our fundamental rights, it will be also void. Third, Article 13 clause 3 defines law for the purpose of article 13, and it gives inclusive definition which includes various forms of laws, because it has mentioned, everything is mentioned. One, so here the laws in force is also mentioned in the article. Laws are also, what are laws? Like ordinance, bylaw, regulation, everything is mentioned here. In these are not judicial interpretation, they are clearly mentioned in the constitution, article 13. Okay, fine. Now come to important doctrines related to article 13. Now you have to remember these doctrine names. They will ask, the doctrine of severability is associated with which of the article? 13, 15, 21, 30. 21 will 21 and article 19 are very important. Always it will be there in the option, remember. So you have to be very clear. So these all are related to article 13 doctrines. Okay, now I already told you this doctrine. Doctrine of severability. Doctrine of severability is, the need of this doctrine arises when there is an issue of invalidity and unconstitutionality of a part of a statute. I told you now, a law is a very big thing. A law has lot of provisions. We are only talking about a part, this part or this part or this part. Part of a statute. Statute means law. Here the question arises whether the whole law, the whole act should be declared void, or only that part which is inconsistent with the constitution. Because see, in the article it is clearly mentioned to the level of inconsistency. So this doctrine was evolved. In order to sort out this problem, the Supreme Court devised this doctrine. The basis of this doctrine lies in the word "to the extent of such inconsistency." I told you, to the extent of such inconsistency term was there. So it led to a lot of problems. People see, constitution is also very difficult to understand that language. So the Supreme Court interprets. Supreme Court is the interpreter of our constitution. It is his main work to interpret the constitution so that clarity comes. This doctrine is subject to one exception. Sometimes it happens that valid and invalid parts of the law, the act, are so closely mixed up that they can't be separated. Thus, the whole act has to be declared void. I told you, if some provisions are closely related, so we can, if you separate it also, it will affect our fundamental rights. So in that case, the whole law has to be declared void. For example, NJAC, National Judicial Appointments Commission 2015, the whole law was declared void. The whole law, not a single provision, but it was connectivity. A lot of provisions were kahin na kahin, they were connecting to other provisions. So the whole law was declared void. To know whether they are separated or not, we have to see the intention of the legislature. Like, what was the intention? Legislature would have enacted valid act without enacting void part. If the answer is yes, then it is severable. If the answer is no, then it is not severable. So simple. These two statements are simple. Just you need to understand some part of the law, if that is inconsistent, so that will be void. If it is connected to the whole other provisions, then the whole law also can be declared as void. So doctrine of severability, article 13. Now come to doctrine of eclipse. Doctrine of eclipse. Now this is also very much important. It is also related to article 13. So direct question can also come. What are the doctrines related to article 13 or inconstitutionality of laws with respect to fundamental rights? They will not clearly mention article 13. What are the doctrines? What are the Supreme Court doctrines or the Supreme Court interpretations? You have to mention only this. You have to explain it. That's it. You have to mention the article definition and you have to explain it. Doctrine of eclipse. It simply speaks about violation of fundamental rights which should not in any case be infringed. Okay. If there is an existing law which is inconsistent with the fundamental rights prior to the constitution came into force. Now this doctrine deals with, this is the term prior to the constitution came into force. So then it becomes inoperative from the date the constitution come into force. In this situation, existing laws remain eclipsed and dormant to the extent it comes under the shadow of fundamental rights. Suppose a law is there, okay? Suppose a law is there, it is prior to the constitution and it is inconsistent with the fundamental rights, so it becomes eclipsed and dormant. But it is not dead, it is dormant and eclipsed but not dead, and as soon as the eclipse is removed, the law begins to operate from the date of such removal. If you remove this part, the law chalu hai wahan se. It will continue. So just remember one case, you will get clarity from one case. From this case you will get clarity. Because in Narayan versus State of MP 1955 case, okay, it is an excellent illustration of the doctrine of eclipse. See, there was a Motor Vehicle Act, okay. The provisions of the Motor Vehicle Act enabled the provincial government to operate to entire motor transport business to the exclusion of private transport operators. So this was a pre-constitutional law, that because that is where the term provincial is there. So it's a pre-constitutional law before constitution was there. So what it did, it enabled the provincial government to operate the entire motor transport business to the exclusion of private transport operators. They excluded private transport operators. Just think, okay. So if they exclude private transport operators, so the provision became void. Why? Because the constitution came into force 1950, and this exclusion of private transport operators is violating Article 19(1)(g). Now what is Article 19(1)(g)? To practice, all the citizens have right to practice what? Any profession. Any profession. ठीक है? To carry on trade, occupation, or any business. ठीक है? So Article 19(1)(g) says कि you can practice any profession, anyone. Not why only government people, private people, anyone can practice, citizens, to carry out trade. So here you are excluding this private transport operator. So it is affecting Article 19(1)(g). That is why the Supreme Court, it went to Supreme Court, because it is violating, which gives fundamental right to practice any trade, profession, or business to the citizens of India. The state could earlier carry on business to complete or partial exclusion of citizens, which was against earlier. The state means the British government. Now it was totally against 19(1)(g). So the Supreme Court observed that the amended provisions were void since 1950. The impugned provisions was eclipsed from the time being on account of the provision of Article 19. Because in 1950, Article 19 came. Okay, law was there. Because Article 19 came, because it is affecting Article 19(1)(g), that provision was eclipsed. But it was not dead. That provision was eclipsed. So that provision was eclipsed. Okay. Now what happened? That provision was eclipsed. Now by first Constitutional Amendment Act 1951, the government amended Article 19 after this incident, and the eclipse was removed by insertion of Article 19(6) Clause 2. In 19(6) Clause 2, the government said that the state, like nothing can affect the state in making any law. It means the government can do. The government can do. To carry out, the government can make a law. See, Article 19 comes with restrictions also. You cannot simply come and say, I have freedom to say anything, you can go and... No, it comes with restrictions. So in this Article 19, Article 19 Clause 6, to it said ki, okay, nothing can affect the state or prevent the state from making any law to carry out any business, trade. Means it can exclude. If the government wants, it can do. It means our government brought the same thing. So this eclipse was again removed by insertion of this. At the very moment the limitation was removed, the impugned provision again became enforceable. It was held that all laws existing or future which are inconsistent with the provision of Part 3 of the Constitution are by express provision of Article 19 rendered void to the extent of such inconsistency. Because now it was a problem. Okay, but they added this in the Constitution. Yes, the government can do. Previously it was not there. In 1950, when Constitution came, 19(6) Clause 2.2 was not there. That is why it was eclipsed. But again the government added this in Constitutional Amendment 1951. So then again it started running. That eclipse went and everything. Now the government can do. When we read Article 19, we'll come to that. Understood? If anyone has any doubt, ask me right now. I hope everyone understood.
Sir, there is one doubt.
Yeah, ask me.
Sir, suppose if there was any law inconsistent with fundamental right and that was framed before the commencement of constitution, then only that inconsistent part of the law will be declared as void, or whole of the law will be declared as void?
Only the inconsistent part. That is the doctrine of severability.
I know that is a doctrine of severability, but it was a pre-constitutional law.
Okay, if a pre-constitutional law, then the Supreme Court used this doctrine, eclipse doctrine.
Sir, if I may.
Then whole law will be eclipsed, no?
Not whole law. That particular provision. Law is not dead.
Provision.
That everywhere that provision will be eclipsed.
That provision will be eclipsed.
That provision only. Whole law will be there. Law will be there. Yeah.
13 also says that law will continue to be ineffective, like pre-constitutional laws will run concurrent.
Yes, they'll run. Only that provision will eclipse.
And if situation arises, like if valid and invalid part of the law cannot be separated, then whole law has to be declared void.
Then whole law. Other if अगर separate नहीं हो पा रहा है कहीं ना कहीं, that particular problematic provision has connections with other provisions also, like the whole law, then the whole law has to be stopped.
Okay, sir.
Okay.
Thank you, sir.
Yeah. Next. So what happened here is, okay, so such laws are not dead for all purposes. They are valid as regards pre-constitutional rights and liabilities, because at that time there is no fundamental rights of citizen. This particular doctrine is for pre-constitutional. Just remember that. Yes, it is somewhat.
एक चीज बस add करना था. Basically, now there are recent cases also which say that even post-constitutional laws, there also doctrine of eclipse can be applied. उनका reason ये है कि there are, for example, there are certain fundamental rights, no, which are just applicable to citizens and not applicable to non-citizens.
Non-citizens, yes.
Right. So, जैसे for instance, Article 19, that is not applicable to non-citizens.
Exactly.
So, अगर कोई law eclipse हो जाए, बोल दे कि वो लॉ नहीं लागू होगा, but फिर भी that will not be dead because that is still operative against.
Still operative. हाँ, वही तो लिखा है यहाँ पे. Operative still रहेगा.
तो वो पोस्ट कॉन्स्टिट्यूशनल लॉस के लिए भी एप्लीकेबल है ये डॉक्ट्रिन सर.
ओके, तो अभी पोस्ट कॉन्स्टिट्यूशनल लॉस के लिए भी हो रहा है, राइट?
राइट सर.
ओके, ठीक है. So such laws are not dead for all purposes. They are valid as regards pre-constitutional rights and liabilities, because at that point of time there is no fundamental rights of citizen. Even after constitution came into force, it remains valid against non-citizens because they do not have fundamental rights like Article 19. So उनके लिए तो रहेगा. So the law remains in a dormant or a moribund condition only against citizens, because we are talking about Article 19 here. So in this context, this statement is there. That's it. Okay. Now come to doctrine of waiver. Doctrine of waiver is very easy. This doctrine was formulated by American jurist. The doctrine raises a question: Can a citizen waive his fundamental rights? क्या आप अपना fundamental right को waive off कर सकते हो? Can a citizen waive his fundamental rights? ठीक है. This important question was considered in Basharnath case in 1959. ठीक है. यहाँ पे clear cut you have to remember, citizens can't waive off their fundamental rights. If a statement comes in a prelims or any kind of exam, consider the following statement. Simply, no, you cannot waive off your fundamental rights, because justice said the fundamental rights are transcendental in nature, conceived and enacted in national and public interest, and therefore could not be waived off. ये जो राइट्स, मतलब हिंदी में अगर बोला जाए, दिस राइट्स जो हुआ है, जो बनाया गया है, ये एक नेशनल पब्लिक इंटरेस्ट में, ये आपके अकेले, ऑब्वियसली अकेले का तो है ही, लेकिन जो बनाया गया है, इनेक्टेड हुआ है, जो कंसीव हुआ है, ये एक बहुत ही बड़े लेवल पे पब्लिक इंटरेस्ट और नेशनल सोच के बनाया गया है. ये आपकी पर्सनल सोच के नहीं बनाया गया है. सो आप खुद वेव ऑफ नहीं कर सकते. दैट्स, यू कैनॉट वेव ऑफ. सो इन दिस केस इट वाज हेल्ड दैट सिटीजंस कांट waive his fundamental rights. The reason behind it, it's not only meant for benefit. That's what I said. It is not only meant for your benefit of an individual. It is also an obligation upon the state by constitution, and no person can relieve the state from this obligation. If you waive off, the state becomes in the upper hand, na? If you waive your fundamental rights, the state will again come the upper hand, and again it will become a tyrannical government again. So there is no purpose of fundamental rights then. Why fundamental rights came then? So you can't waive your fundamental rights. Okay, fine. Shankari Prasad case not that much important, but read kar lete hain. The court held that the power to amend the constitution, including the fundamental rights, because fundamental rights also comes under constitution, right? So the power to amend the constitution, including the fundamental rights, was contained in Article 368, because Article 368 ke antargat you can amend a constitution. Article 360 is nothing but amendment, and that word law in Article 13 we studied did not include. I told you it did not include the amendment of any. It included ordinance, rule, bylaws, etc., etc. But it did not include amendment of a constitution, which was made in the exercise of the constituent and not legislative power. Because the statement means constitution means you are totally amending the constitution. Okay, obviously it may affect. For example, I'll give you an example. See, NJAC, okay, NJAC, National Judicial Appointments Commission, it was done by amending the constitution, right? Amending the constitution. Now you tell me, why the Supreme Court declared this as void? If the question comes, did it violate article this article, Article 13? Yes or no? Did NJAC violated Article 13? Yes or no? Obviously no, it did not violate Article 13. Not because of that. It violated Article 50. It violated the basic structure. What is the basic structure? Independence of judiciary. It violated independence of judiciary, because in NJAC commission, one law minister will be there. For appointment of judges, one law minister they are putting. It means it is affecting Article 50, that is separation of powers between judiciary and executive. Basic structure, independence of judiciary. If law minister will be there, so it will lead to bias. So where is the independence then? Because of these two, the Supreme Court violated, made this law as void. Not because it affected Article 13, because there is no point in Article 13. In Article 13, the law, under the ambit of the term law, these things do not come. Amendment do not come at first point. Okay, so you can just remember, amendment do not come under the ambit of law, because it is not mentioned in the article. That's it. Okay, next. Okay, next. Same thing, doctrine of eclipse, same thing is mentioned, but before which we studied, it was in a very detailed way. You can just go through it in a short format. Revision ke liye easy ho jata hai. Okay, same thing. Civica General, this Motor Vehicle Amendment Act, if you read from here, you can't understand. If you read from this book, you can't understand here, because you do not know what happened in this Motor Vehicle Act. But above book we studied, we clearly understood what exactly happened. Because they always do not go for short trick. एग्जाम पे शॉर्टकट नहीं होता है, खास करके दिस काइंड ऑफ एडमिनिस्ट्रेटिव एग्जाम्स में 30 पेज पढ़ के चले जाएंगे, हमको इसका एडिटेड वर्जन दे, तो इससे तो दूर रहो। पहले आप जितना पढ़ोगे एक चीज को 3-4 बार, आपका कॉन्सेप्ट उतना बिखर के आएगा, और वही चीज आपको प्रीलिम्स में हेल्प करेगा, मेंस में आपका एनरिचमेंट बनाएगा। और ये थंब रूल बोल रहा हूँ, ठीक है, थंब रूल। दोज आर सेइंग कि लिमिटेड स्टडी करो, दे आर नॉट सेइंग द राइट थिंग। टॉपर्स कभी भी लिमिटेड स्टडी नहीं करते हैं, वो टॉपर्स हैं इसीलिए वो वहां पे हैं। हम यहाँ पे बैठे हैं बिकॉज वी आर नॉट डूइंग लिमिटेड, वी आर डूइंग लिमिटेड स्टडी, दैट्स व्हाई हम घर पे बैठे हैं। इट्स अ वेरी बेसिक थिंग। ओके, ठीक है, नेक्स्ट। ये वही सब चीजें नॉट रिक्वायर्ड। वेवर वही हो गया, बस एंड अर्थ केस पढ़ दिया हमने। फंडामेंटल राइट्स कैन नॉट बी वेव्ड अंडर द कॉन्स्टिट्यूशन ऑफ इंडिया। नाउ एक एक्स्ट्रा चीज मैं पर्सनल लॉस के बारे में पढ़ाऊंगा। ट्रिपल तलाक अभी न्यूज में था, तो पर्सनल लॉस के बारे में भी जानना जरूरी है। यू नीड टू नो कि डू द पर्सनल लॉज, जैसे कि ट्रिपल तलाक था, बहुत सारे पर्सनल लॉज होते हैं, लाइक क्रिश्चियंस का, मुस्लिम्स का, हिंदूज का पर्सनल लॉज होते हैं। तो डू ऑल दोज लॉज कम्स अंडर द आर्टिकल 13? सी इन दिस केस, नरसोप्पू केस और सम बॉम्बे केस हुआ था, द चीफ जस्टिस सेड that it is very clear pointer to the intention of the constitution making body to exclude personal law from the purview of article 13. See, the Constituent Assembly, when Constituent Assembly comes from the Cabinet Mission, 1946. Okay, so when they were making the Constitution in the Constituent Assembly, the Constituent Assembly defining law in Article 13 have expressly and actively used only the expression custom or usage. Now only we studied the Article 13 where we have the term as custom or usage. There was not a term of personal law. There it was a, so again interpretation happened. Things went to court. Now the court said there was the term custom and usage. Now what custom? Now obviously if a word custom comes, usage comes, so obviously personal laws आएगा उसके ambit में. Clearly not defined, na? And I've omitted personal laws. Now the honorable court observed that it is very clear pointer to the intention of the constitution making body or the constitution makers to exclude personal laws from the purview. अगर उनको करना ही होता तो वो पर्सनल लॉ को डालते उसके अंदर. If they wanted to put, they would have put it, but they did not put. That's why they put custom or usage. But obviously, constitution is prone to interpretation. So this above case ruled that personal laws do not seem to be laws in force under Article 13 of the Constitution, as they are supported religious precepts and customary practice, and principle in Part 3 can't be applied. Principle in Part 3, principles in fundamental rights cannot be applied to personal law. Just remember this point. Okay. Okay. समझ में आ गया? Next. Same thing we have covered. Constitutional amendment. They will not come under the ambit of law. Clearly mentioned. We have already covered this. This is the evolution. No need to remember. Even in if you see the government, what the government did, because things were not the same thing in 1970s or 1967, खास करके गोलकनाथ case में. Okay, so here in 24th Constitutional Amendment Act, the government what it did, clause 4 add कर दिया Article 13 में. They added a clause 4 in 1971 and added that nothing in Article 13 shall apply to a constitutional amendment. They added it. It was not the case before. They added it. In now it is in the constitution. Nothing in this article shall apply to a constitutional amendment. Clause 4 was added in 1971. Now see, in state exams they will ask this, in which of the following amendment this particular provision they will mention कि constitutional amendment cannot be done. Then you have to remember, it's not for UPC exam, but state level they'll ask in 24th Amendment Act 1971. It was added, clause 4. They'll not ask you what is the clause name. They'll simply ask this amendment name and they'll put this. Okay. Similarly, if you're adding here, so you have to also add in Article 368. That is also constitutional amendment, na? Because both are related. So clause 3 was added to Article 368 to provide that nothing in Article 13 will apply to amendments made under Article 368. Okay. Fine. Same thing, not required. Okay, equality before law. So equality before law, this article states that the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. This is the statement. I'll tell you what is it. Okay. Equality before the law or equal protection. You have to know exactly what is the difference. I'll tell you. It guarantees equality before the law or equal protection of laws to any person within the territory of India. Within the territory of India. As simple as that. Within the territory of India. Okay? The state shall not deny. State matlab government shall not deny equality before law to any citizen as well as non-citizen on the ground of, these are the grounds. You can't make your own grounds, first of all. On the ground of caste, religion, region, place of birth or sex. You have to remember this. This is the ground. Okay. We will not deny. Now, what is equality before? It is a negative concept, which implies absence of any privilege in favor of any individual. Absence of any privilege in favor of any individual. You cannot simply give, you can't give a privilege to a particular person. So equality before law, and so equal subjugation of all law classes to law. Everyone are equal. It means prime minister or peasant, all are equal before the law. इसे है ना, हर कानून के आगे हर कोई एक है. So that is this concept. ठीक है. Equal protection of law is a positive concept which implies that equals should be treated equally and unequal should be treated differently. Obviously it is a positive concept. This is a negative concept. How can you say, see सुनने में ये बहुत अच्छा लगता है, right? हर कोई लॉ के आगे इक्वल है. आप ऐसा नहीं कर सकते. लॉ के आगे हर कोई इक्वल कैसे हो सकता है, मुझे बताइए पहले. There are poor people, there are rich people, there are middle class people. How can, so it is a negative concept. Equal protection of law is a positive concept. It implies that equal should be treated equally and unequal should be treated differently. Taxation is the biggest example of this. Slabs है ना, जो ज्यादा कमाता है, those who earn more, they will be taxed more equally. इसी slab में unequal should be treated differently. Taxation, it's nothing but a law. Income tax, 1961, Income Tax Act. It means all laws cannot apply uniformly to all. We cannot say this is positive, this is reality. This is just like for the sake of saying we can say, but the reality is this. So in the mains question, GS2 पे पहला क्वेश्चन आ सकता है, difference between equality before law and equal protection. You have to write these two statements and you have to explain as I am telling you. You have to explain in your own way with some examples. Give your own examples. Okay. And one more thing I want to say कि ये एग्जाम मेंस का मतलब इट्स नॉट जो रट्टा मारते हैं ना वैसा नहीं है ये. आप जितना कॉन्सेप्चुअली समझोगे अपने मदर टंग में, आप उतना फ्लुएंटली आंसर आप लिख सकते हो. आई एम टेलिंग यू ऑनेस्टली. यस, देयर आर सम क्वेश्चंस, डायरेक्ट क्वेश्चंस यू हैव टू मतलब यू हैव टू मग अप. फॉर एग्जांपल कोई एक्ट का बारे में आ गया, explain the environment protection or explain the biodiversity act, so you have to remember, oh, I understand, but still then I'm talking about these particular category stuff in खास करके जो polity का होता है, थोड़ा बहुत जो थोड़ा analysis होता है. So you have to give your understanding part, वहीं पे मार्क पड़ेगा because main से ही सब कुछ होगा, right? Okay. Now what is class legislation? Article 14 forbids class legislation. It does not forbid reasonable classification. There are two different things. Class legislation, reasonable classification. Yes, it forbids. आप थोड़ा बहुत तो classify करना पड़ेगा ना, हम सबको एक जगह नहीं रख सकते. So it does not forbid it. It supports reasonable classification of objects and transactions by the legislature for the purpose of achieving specific needs. You cannot simply come and say कि उस गरीब को क्यों स्कीम्स में पैसा मिल रहा है, मुझे क्यों नहीं मिल रहा है, आई एम नॉट गेटिंग, उनको दिया जा रहा है. नो, स्पेसिफिक नीड को अचीव करने के लिए द गवर्नमेंट ब्रिंग सम स्कीम, सम लॉ, सम रूल्स. तो रीजनेबल क्लासिफिकेशन इज ओके, बट क्लास लेजिस्लेशन इट फॉरबिड्स. We'll come to that. The class legislation is that which makes an improper discrimination. So ये जो class legislation है, it is an improper discrimination by conferring particular privileges. That is the first case. That is a negative concept. The class legislation is which makes an improper discrimination by conferring particular privilege upon a class of persons arbitrarily selected. If you are arbitrarily selected and giving them some privilege, the term should be privilege. That is class legislation. No, we do not have here place for class legislation. What Article 14 prohibits is class legislation. It prohibits. आप एक particular class को आप उनको you cannot give them a particular privilege. So class legislation को prohibit करता है, class classification को नहीं करता है. Some classification हो सकता है. It is accepted. You can do it for the purpose of legislation. होता है क्लासिफिकेशन, अलग अलग चीज होता है क्लासिफिकेशन. हम रिजर्वेशन करते हैं, हम अलग अलग चीज टैक्सेशन पे अलग अलग जगह को अलग अलग क्लासिफाई करके स्लैब्स, वी क्रिएट स्लैब्स, राइट, बेस्ड ऑन आवर इनकम. सो एक्सेप्शंस टू द रूल ऑफ इक्वालिटी under article 359, when the proclamation of emergency is in operation, the enforcement of article 14 may be suspended during that period. Yes, exceptions to the rule of equality. Now we are Examples, we are connecting the emergency. We'll cover this emergency. You must have covered, you must have gone through emergency chapter. Article 359 जब उसके अंदर when proclamation of emergency operation, the enforcement article may be suspended during that period. It is written there in the constitution. It can be suspended. But there is an so at that time equality वगैरह चीज नहीं आएगा because the emergency is going on. Article 361 already covered in our last class. Provide the president. We covered about president, right? So president governor shall not be answerable to any court for exercise and performance of the power and duties of the office. They also enjoy exemptions from civil and criminal proceedings until certain conditions are fulfilled, obviously. So these are, so you cannot say why the governor is getting this exception, why I am not getting. You can't say this. So there are exceptions. MP and MLA are not liable in any case of anything done or said anything in the house, within the house, not outside, within the house. Article 105, 194. We'll cover that when we reach there. Article 100 already covered. When you read my lecture in YouTube, you can read Parliament chapter. Part 2. Foreign diplomats are immune from jurisdiction of courts. Yes. Again, these are exceptions to equality. Examples. Now, reasonable classification. So here what you see. Now, just tell me one thing. In these exceptions, what are you seeing this? These are special privileges. These are not reasonable classification. Do not do this grave mistake. These are not reasonable classification. This is class legislation. These all are class legislation. Article 14 prohibits, but there are some exceptions. Okay, while studying, you have to study like this. These are, because the point is when you study ना हम एक normal flow पे पढ़ लेते हैं तो जो main concept होते हैं we miss them. That's what affects us in exam. Because the format of exam is conceptual. It's 75%, 70% conceptual, 30% factual. And fact are also kind of linked with concepts. These are examples. These are special privileges. President, governor, MPs, foreign diplomats.
Excuse me, sir, there is one doubt.
Yeah, tell me.
Sir, here it is written in the Article 361 that president and the governors are not answerable to any court for the exercise and performance of power and duties, and we cannot proceed any civil and criminal proceeding until certain conditions are fulfilled. But sir, I have read in the chapter president that we cannot undertake criminal proceeding against a president whenever he's during the term of his office, but civil proceeding can be initiated against him after giving 14 days prior notice.
Yeah, that 14 days is under certain conditions, na?
Okay.
See, those things will mention there, but here that is what certain conditions. That's why it's mentioned this line until certain conditions fulfilled. What is?
Sorry. Criminal proceeding cannot be initiated against him, but civil proceeding can be initiated against the president after giving him 14 days.
After giving him notice. Notice is there. That is the condition.
That is a condition.
Okay, yeah. Sir. Tell me, कौन पूछ रहा था अभी?
No, the certain conditions only. I understood.
Understood, Vignesh?
Yes, sir. No, I was adding some point, but you told that point.
अच्छा. Okay. समझ में आ गया? अब तो ये हो गया तुम्हारा class legislation, because these are particular privileges given to a particular class of people. ठीक है? अब आ जाओ reasonable classification पे. Okay, this is possible. Reasonable classification will be there. Just remember these terms. I have mentioned all this in my channel. If you search now, it will come. All these things will come. Test of reasonable classification कौन से article का है, which article? All these questions you have. तो इसके बाद question करोगे जब मेरे channel से या फिर मेरे test series से पता चलेगा आपको कि exact हाँ we have studied this, now we are able to answer. Okay, fine. A classification to be reasonable should fulfill two tests. You have to remember. So you have to fulfill. It should not be arbitrary. If you are a government, you are classifying. You simply can't arbitrarily classify. There should be reasoning behind everything. This is a poor people. They want some special needs. Then you classify. That is okay. But it should not be arbitrary, artificial, or evasive. It should be based on an intelligible differential, like that logic, reasoning, intelligence. That is some real and substantial distinction should be there. which distinguishes persons or things grouped together in one class from others left it out. When you are grouping things or you are classifying things, it should not be arbitrary. Next, the differential adopted on the basis of classification must be reasonable nexus with the object sought to be achieved by the act in the question. If you are doing this classification, okay, if you are doing this classification, you have to, like, obviously you will be doing for some reason, right? First, to get some output, right? So it should have a reasonable nexus with the object sought to be achieved by this act in question or by this rule in question. Okay. Presumption is always in favor of constitutionality of an enactment. In favor of taxation, legislature enjoys greater latitude of classification. I told you the taxation example. वहाँ पे बहुत this particular thing is very well understood, because we get to classify a lot of people. We all pay different taxes, right, based on our income. Okay, fine. So we are done with this. Next, examples of violation of reasonable. Now, reasonable classification can be examples of when you violate it, or this this exceptions. Classification between pensioners retiring before a particular date and after that date. Now you are violating this. We are classifying between pensioners retiring before a particular date and after a particular date. Reservation of seats in medical college on the basis of domicile or institutional preference regardless of merit. Now we told it should be on a merit basis. It should be rational, right? It should be logical. Now this is one more example, no need to remember. You got to know, like we know, like examples you can make on your own, but the thing is you need to know the basic concept. Now examples of permissible classification. Okay, some examples of permissible classification. Here, debarring persons who are in police custody or prison to vote in an election and not those who are in preventive detention. Remember this statement. You cannot vote in an election if you are in police custody, but not those who are in, but if you are in preventive detention will cover in Article 20. If you are in preventive detention, if you are detented, preventive for जैसे कि अभी महबूबा मुफ्ती को हुआ था 370 से पहले, but you are entitled to vote. An act which applies to Marwar portion of Rajasthan only. कोई एक act होगा, I do not know. But still some classified, but the thing is it is being classified, right? No need to know what is that act, but at least you know this is a permissible classification. An act creating a monopoly in favor of the state, again permissible classification. Higher tax on cinema houses situated in post localities and having large sitting capacities, and lower tax on cinema halls located in poor localities and having small capacities. Yes, now this Andhra Pradesh issue happening, Andhra Pradesh cinema hall ticket pricing issues happening. Imposing higher rate of road tax on company owned cars and motorcycles than individual owned. Yes, road tax उनके ऊपर ज़्यादा लगता है. Difference in imposing sales tax on cooked food sold by luxurious hotels and modest hotels. Yes, sales tax में difference भी आता है. Picking up a minister for the purpose of inquiry and setting up a commission to go into charges of corruption. Yes. So obviously the examples are not required, but you should know what is the meaning behind it, and it is related to which article. That will work for your exam. No, everything are not important here, but some you have to know. Okay, this is the thing, this is the statement, or this is the term or a doctrine, or this is an like explicit statement or a term is related to this article. Just that much will also work for exam. Okay. Okay, next. Now what is the new concept of equality? Okay, fine. 1993 mein this equality, this principle of equality is also ancient the basic structure of the constitution. Now I'll tell you one thing, just remember, very important. Basic structure of the constitution के अंदर बहुत सारी चीजें, lot of things comes under basic structure of the constitution. Over judicial pronouncement. It's not only Keshavananda Bharati. Keshavananda Bharati just said and added some basic structure. Then afterwards, lot of basic structure started getting added. And in Indira Sawhney case, we know Indira Sawhney is related to this OBC and all this reservation and all, we know. Okay, fine. But that case, Principle, obviously it is related to equality also. Principle of equality is a basic structure, remember. Okay. And one more thing, basic structure is not like what is that word, I do not remember exactly, but Hindi में अगर बोला जाए कि basic structure कोई सुप्रीम कोर्ट का नहीं है, मतलब that exactly term I do not remember. There is I have framed an MCQ in my channel, you can go and check.
Grunnom sir.
क्या क्या?
Grunnom.
नहीं मतलब वो अपना नहीं है, मतलब वो सुप्रीम कोर्ट का जैसे मतलब सुप्रीम कोर्ट का मोहताज नहीं है, अगर मैं हिंदी में बोलूँ तो. वेरी इजी वर्ड, मुझे याद नहीं यार, मैंने खुद लिखा था, मैं बोल दूंगा ग्रुप में भेज दूंगा, लेकिन मतलब उनका नहीं है. सुप्रीम कोर्ट ने बोला कि ये हमारा नहीं है, हमने बस उनको एक बोला है कि हाँ वी डू नॉट ओन दिस, यस वी डू नॉट ओन द बेसिक स्ट्रक्चर ऑफ आवर कॉन्स्टिट्यूशन, वी डू नॉट ओन इट. और उस प्रकार का कुछ स्टेटमेंट आएगा कि द बेसिक स्ट्रक्चर ऑफ आर ओन्ड बाय द सुप्रीम कोर्ट और सम सिनोनिम ऑफ द टर्म ओन, OWN, नो इट इज रॉन्ग. These are not owned. These are not owned by anyone. These are all interpretation given by the Supreme Court on various judgments. Okay. Fine. New concept of equality. So the new concept of equality is propounded in case E.P. Royappa versus State of Tamil Nadu in 1974. It provides that equality and arbitrariness are anti-ethical to each other, and whatever is arbitrary or unreasonable is against equality. You have to, this new concept of equality, these all terms will help you immensely in GS2 answer writing. It will enrich your answer like anything. So equality and arbitrariness are obviously against each other, and whatever is arbitrary is against equality. Okay, court said. Okay, 1974, these are the new concepts. Bhagwati just said that equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while the other the whim and caprice of an absolute monarch. Arbitrary is nothing but it is preserving that monarchical attitude. Okay. When an act is rule of law means what? Rule of law means no discrimination. No discrimination. Rule of law. Okay. Okay, so whenever an act is arbitrary, it is implicit in that it is unequal, both according to political logic and constitutional law, and is therefore violative of Article 14. Anything which is arbitrary, it is implicit. So पता चल ही जाता है कि according to political logic and constitutional law कि हाँ it is arbitrary or it is violating Article 14, and if it affects any matter relating to public employment, it is also violative of Article 16. Now the thing is, what happens is, again, two articles always come at striking at each other. Article 14 and Article 16 strike at arbitrariness in state action and ensures fairness and equality of treatment. Article 16 में reservation दिया जाता है, तो equality कहाँ है फिर? And Article 16 में there is a provision, yes, the state can make reservations. We'll come to that when you study Article 16 in the next class. And Article 14 is talking about equality. So these are the debate which is still going on and which will always go. Now these are the things. Now that's the beauty of our constitution. This is the debate. Okay. Article 14 strikes at arbitrariness because an action that is arbitrary necessarily involves negation of equality. Okay. What is rule of law? Rule of law, it requires that no person shall be subject to harsh, uncivilized or discriminatory treatment, even when the object is securing of the paramount existence of law. That's what I said. No person shall be subject to harsh, discriminatory treatment. Rule of law means you have to use this word. Okay? Even when the object is securing of the paramount existences of law and order. Article 14 requires not only reasonable classification, but also, yes, reasonable classification is there, we are okay with, but there are two conditions, right? That must be fair, just and reasonable, and that also should preserve the term rule of law. You can use this sentence also. Reasonable, okay, but it can't be arbitrary also. It has to preserve the value of the term rule of law. जबलपुर केस में क्या हुआ था? The then Judicial India said that constitution is the man. Now this is the term which will come in GS2 mains. Analyze or elucidate. Now you have to explain. You have to explain your own feeling. You have to explain your own concept. What you have known about this law, known about this act in your last 2 years. You have to write it in 150 to 250 words. and you have to write it very nicely. मतलब एक बहुत ही अच्छे explanation दोगे. So you have to show your that कैसे बताऊँ, you have to show your कि आप कितना समझे उस चीज को. The constitution is the mandate, the constitution is a rule of law, and no man can arise above the rule of law in the constitution. इसको आप अपने पर्सपेक्टिव से लिखो. ये आंसर लिख के मुझे दिखाओ, मैं रिव्यू करूंगा, फिर मैं एक्सप्लेन कर दूंगा नेक्स्ट क्लास में. देखो 250 वर्ड्स में लिख के दो. राइट योर ओन थिंग, व्हाट यू नो, राइट, यूज करंट अफेयर, 1-2 एग्जांपल्स, राइट ऑल दीस थिंग्स व्हिच आई हैव एक्सप्लेन्ड इन टुडेज क्लास. यू कैन वेरी वेल राइट इट. ये लिख के मुझे दिखाओ, मैं एक्सप्लेन आपको एक्सप्लेन भी कर दूंगा, आपको अच्छा आंसर को शेयर भी करूंगा. ओके. The classification would not be reasonable if it is made without observing the rules of natural justice. Even an administrative order which involves civil consequences must be made in consonance with the rules of natural justice. It is thus been held that rules of natural justice form an essential component of equality. जो हमारा natural justice है, rules of natural justice को हम उसको भूल नहीं सकते कभी भी. हम जब भी हम equality की बात करते हैं, because obviously in equality the concept of classification comes, because it is allowed in a classification. Reasonable classification is there, but in a reasonable classification, if you are doing a classification, it should not be arbitrary, it should preserve the rule of law, right? तो उस चीज पे natural justice को भी हम छोड़ नहीं सकते. Now natural justice का meaning क्या है? What do you mean by, what are the principles of natural justice? So natural justice means the term here ethics का आता है. हम ethics में पढ़े थे natural justice के बारे में. Natural justice, if you remember, natural justice में आपको morality आएगा, right? आपको morality आएगा, मतलब morality आपका अंदर क्या बोल रहा है, morality right or wrong. और जब morality right or wrong की, जब moral की बात आती है तब law की बात नहीं आता है. Moral values which I have told you in my ethics class, तब law की बात नहीं है. तब आप अपने मोरल को पूछते हो, आप क्या वैल्यूज इनकलकेट किए हो बचपन से लेके आज तक. वो तो एक अलग सा टॉपिक है जो कि मैं एथिक्स में पढ़ाया था, लेकिन फिर भी लाइक फॉर नॉर्मली आप अगर नेचुरल जस्टिस को समझने के लिए आप करते हो तो मोरली राइट और क्या हो, वो आप कभी उसको खराब नहीं कर सकते. आप जब क्लासिफिकेशन दे रहे हो, इफ आर गिविंग क्लासिफिकेशन, रूल्स ऑफ नेचुरल जस्टिस, इट ऑल्सो फॉर्म्स एन एसेंशियल कंपोनेंट ऑफ इक्वालिटी. ओके. Okay. In this case, just थोड़ा examples आप दे सकते हो, relevant recent examples which will help you. So this is the same thing. Jabalpur case जो मैंने बोला, it is a mandate. The constitution is committed to the rule of law. No one can rise above the rule of law. Okay. तो equality is a positive concept. Supreme Court ने बोला equality cannot be applied to legitimize an illegal action. 2006 का केस है. आप equality कर रहे हो, आप equality, you are giving an equality statement, or you are doing a law, you are giving a classification, but it should not be applied to legitimize an illegal action. It can never be. Right to equality, transgender person, Nalsa case, recent. Triple talaq, unconstitutional, because it was violating right to equality. It was violating dignity, Article 21. Begging is not a crime. बेगिंग इज नॉट ए क्राइम. दिल्ली हाई कोर्ट डीक्रिमिनलाइज, 2018 का केस है, 2018 का केस है, हर्ष मंदर केस है. द दिल्ली हाई कोर्ट डीक्रिमिनलाइज द बेगिंग ऑन द ग्राउंड ऑफ राइट टू इक्वलिटी अंडर आर्टिकल 14 बाय रिमूविंग अराउंड 25 सेक्शंस ऑफ द बॉम्बे प्रिवेंशन ऑफ बेगिंग एक्ट 1959. अभी रिसेंटली 2018 में इट वाज इन न्यूज कि डीक्रिमिनलाइज कर दिया. सो यू हैव टू रिमेंबर, बेगिंग जब आता है यू हैव टू रिमेंबर द एक्ट नेम, बॉम्बे प्रिवेंशन ऑफ बेगिंग एक्ट 1959. Because court said begging is nothing but a direct attack on the fundamental rights of the poorest of the lot in their process to somehow access the basic necessities like food and shelter. You cannot criminalize them. Okay. Next, consensual homosexual acts between adults is no more a crime. 2018 का केस है, नवतेज सिंह जौहर, very famous case. दीपक मिश्रा का था जो केस, जस्टिस दीपक मिश्रा unanimously struck down the Article 377 of the Indian Penal Code, equality. Okay, because it is a valid of right to equality. Adultery is no more a crime and husband is not the master of wife. This one also was in news. All these things are all valuable of this. Very Joseph Shine case, very famous case. They struck down the 158 years old section 497. 497 deals with adultery of the Indian Penal Code 1860 and thereby decriminalizing adultery. Decriminalizing means criminal case will not be there. Civil case is there. Adultery is used in a civil case also. Okay, but criminal पहले तो civil case में था, criminal case में भी था, but now they are decriminalized adultery. Supreme Court struck down Article 377 on the grounds that it but Article 14 को violate करता है, 15, 21, everything. Okay. Adultery is a different concept जो कि हम current affair में करते हैं. Okay. Now how you can link examples कब आप दे सकते हो, ठीक है? Recent right to women to enter Sabrimala temple, Article 14 को violate करता है, Article 21 को violate करता है. A majority of 4:1. It means now it was against Article 25 also, but still then the Supreme Court understood no. We have to go by this because see the thing is we are evolving. People are becoming more aware about their rights. It was not the case before because of this digital and all digital media awareness, globalization. We are getting very much aware about our own rights. Okay. Legitimate expectation. Legitimate expectation applies now. It also related to Article 14. Remember, this is the term will come. You have to remember. It applies the principles of fairness and reasonableness to a situation where a person has an expectation or interest in a public body, okay, or private parties retaining a long-standing practice or keeping a promise. For example, a person has a reasonable, legitimate expectation of privacy in his or her house. Everyone has a reasonable expect, right? Privacy, because it is a long practice. We have been doing it. So the doctrine of legitimate, they'll ask you the doctrine of reasonable classification, the doctrine of legitimate expectation. They'll ask you in exam. Has been judicially recognized by Indian Supreme Court, and this recognition has paved way for the development of broader and more flexible doctrine of fairness. Article 14 incorporates this concept, remember. Okay. So we are done with this. Next class में हम article 15, 16, 17, 18 वो छोटा-छोटा article है वो कर लेंगे.
सर एक सवाल है.
हाँ पूछे.
सर कह रहा था कि प्रेसिडेंट के लिए जब इम्पीचमेंट होता है तो उसमें सेशन का होना जरूरी है क्या? सेशन बुलाना पड़ेगा क्या तब जाकर इम्पीचमेंट होगा?
हाँ वहीं पे तो होती है क्योंकि सेशन पे ही तो पास होगा ना.
तो सर प्रेसिडेंट अगर सेशन ही नहीं बुलाएगा, बोलेगा मैं नहीं बुलाऊंगा तब, क्योंकि सेशन तो प्रेसिडेंट की मर्जी से ही आता है ना. प्रेसिडेंट सेशन बुलाता है.
हाँ बुलाता है लेकिन 6 महीने के अंदर तो बुलाएगा ना.
मतलब 6 महीने झेलना पड़ेगा ना अगर कुछ गलत भी करता है.
हाँ तो झेल लो, वो तो झेलना पड़ेगा, लेकिन द पॉइंट इज द मैक्सिमम टाइम इज 6 months, राइट? उसके अंदर सामान बुलाना पड़ेगा आपको सेशन. वो दैट्स व्हाई, इसलिए मैं बोलता हूँ मेरा पार्लियामेंट का चैप्टर पहले पढ़ो. आप पार्लियामेंट का चैप्टर बिना पढ़ के आए हो, इसीलिए यू आर गेटिंग दिस काइंड ऑफ डाउट्स. रीड दैट, एवरीथिंग इज क्लियरली मेंशन्ड. 6 महीना मैक्सिमम है.
यस, ठीक
है.
मतलब 6 महीने तक कुछ भी नहीं कर सकते अगर नहीं चाहे.
हाँ तब क्या करो, जब वो बुलाएगा नहीं तब यू कांट डू एनीथिंग ना. उसके बाद करोगे बिकॉज यू तो आप रेडी करके रखोगे, उसके बाद तो जब बुलाएगा तब आओगे.
सर एक और चीज देखा मैंने कि उसमें लिखा हुआ है कि कोई भी पिटीशन डाल सकता है कि मतलब प्रेसिडेंट को इम्पीचमेंट के लिए पिटीशन. हाँ. तो पिटीशन आदमी भी डाल सकता है ना. आदमी मतलब नॉर्मल मिनिस्टर नहीं होना चाहिए, बाहर का सिटीजन.
नहीं सिटीजन कैसे डालेंगे? वो सिटीजन थोड़ी डालते हैं, मिनिस्टर ही डालेंगे ना.
ठीक है सर,
ठीक है. ओके, सो मैं बस यही बोलना चाहता हूँ कि व्हाट यू कैन डू इज, हम जब अभी जो जिस हिसाब से हम पढ़ रहे हैं, हम एक चीज छोड़ भी नहीं रहे, वी आर नॉट लीविंग एनीथिंग, राइट? सो हम इस तरीके से जाएंगे ताकि देखो जल्दी खत्म करके कोई फायदा नहीं है. आप सब लक्ष्मीकांत कहीं ना कहीं साइड में पढ़ ही रहे हो. अब इफ यू आर डूइंग समथिंग वी शुड डू टू द हाईएस्ट पॉसिबल मैनर. ओके, वी शुड नॉट सिंपली डू इट इन अ मीडियोकर मैनर. मीडियोकर मैनर सब करते हैं, ठीक है? हम हाईएस्ट पॉसिबल मैनर में करेंगे ताकि 100% एक्यूरेसी हमारा पॉलिटी में रहे. दैट्स वाई मैं थोड़ा डिटेलिंग पे जा रहा हूँ ताकि यू मतलब आपका कॉन्सेप्ट जो है वो पूरा क्लियर हो जाए, एक ही बारी में आपका कॉन्सेप्ट क्लियर हो जाए. ओके फाइन. ओके, विल मीट नेक्स्ट क्लास. थैंक यू.